Good morning and welcome to this webinar. We are really excited for this. Mitch is a good friend. This is how experts can persuade with clarity, and we're going to touch on about 4 or 5 different topics here today. And we're excited that you're going to be here for these. We're talking about how to immediately connect with a lawyer and get hired, filling needs and fixing problems. We're going to talk about some depositions that help settle cases and win trials. We're creating anticipation. Sorry, folks. Seems like we've got several folks being able to use my abilities here. I'm going to stop your videos. And we are going to talk about creating anticipation and drama at trial, and when giving the jury everything they want, keeping the relationship strong after the verdict, how to stay top of mind, and then persuade or compel the attorney to contact the expert in the first place. That's kind of our overarching little view of what we're going to be doing here today. And we will turn it over to Mitch in just a second. A little background on Mitch. He's a good friend of mine. I want to start with that. He's a good friend of Experts.com. Mitch Jackson enjoys combining law, social media, tech, and technology to disrupt, hack, and improve his clients' companies, causes, and professional relationships. He's an award-winning 2009 Orange County Trial Lawyer of the Year and the 2013 California Litigation Lawyer of the Year. He was recently profiled in Inc.com and has appeared on stage the past 2 years at Tony Robbins' Marketing Mastery. So, Mitch, thanks so much for being here. Appreciate it. Excited for what we have today. And we will turn it over to you and again, folks, we're going to talk about 45 minutes and then we'll have about 45 minutes for Q&A.
Sounds good.
Look forward to it.
Thank you, Nick. Thank you, Experts.com. It's good to be here, everybody. And I love seeing all the Nick Rishwains on the screen. Can we ever have too many Nick Rishwains?
Never.
Right?
That's
what it's all about right there. And Nick, I want everyone to know that if there are questions, whether they're in the chat, whether they're texting you with questions, interrupt me. No big deal. Okay. I want to answer as many questions as I can. But I thought what would be fun is go through the entire cycle of expert witness / attorney, the retention, depositions, trials, staying top of mind after the case is done. And just to give a little bit of context to everyone where I'm coming from, 35 years of trying cases, litigating cases in Southern California, literally hundreds and hundreds of experts have been involved in my cases and in my lives. I've watched what the good ones do. I've watched what the bad ones do. And today what we want to talk about are things that the really good experts do well to initially be retained by a lawyer, okay? What they do well during depositions to help set up the possibility of a high settlement and or further leverage getting ready for trial, what good experts do just before and during the whole trial process, and then after the verdict, after maybe it's a settlement that happens halfway through trial, what those same experts do to remain top of the list for future retention purposes.
Keep it separate. I guess we're the other way.
And so I'm just going to keep talking. I know we've got some live audios and things like
we
this.
have some live
How
audios. Please mute yourself. Please mute yourself if you're here.
I'm in the middle of a video seminar. So
Yes, you are, sir.
Yes, you are. Please mute yourself.
Okay.
So, Nick, I got it. So we're good. So listen, you guys, if you guys are watching, one of the fun things about technology, one of the fun things about trial is things happen. Unexpected things happen. And the good experts are the ones that can do the dance around those unexpected situations, whether it's when you're meeting a lawyer for the first time, whether someone throws you a curveball question during a deposition, whether the judge issues an order at trial that really kind of throws you off your game a little bit, you got to be able to dance. And you got to be able to do that dance in a way where you wrap your arms around these unexpected situations, because that happens. Having said that, 90% of the time, what happens is in your control. And so for those of you watching, a lot of people are clicking in for whatever reason on Zoom under Nick Rishwain's account, and that's great. We're glad to have you here, but just make sure that you're muted so that we don't interfere with everyone else's experience. Let's go back to getting retained in the first place, getting on that attorney's radar in the first place to be hired as an expert witness. Here's the way it goes down 90% of the time. 90% of the time, most lawyers take a file, take a case, and this is not the right way to do it, but this is reality. They think they're going to settle the case. They think the liability is clear. They think they understand the issues involved in a case. And 5 months go by, 8 months go by, and they realize during the pretrial procedures in your respective courts, oh my goodness, I need an expert witness. I need 3 expert witnesses. I didn't think about that issue. And so they need to retain an expert witness. And this is what we see most of the time. So in those types of situations, you want to be that expert witness that the attorney or the law firm's aware of, realizes they can reach out and consult with or retain to help them with the case. That's one scenario. The other scenario are lawyers, and I'd like to think we fall into this category, lawyers that take big catastrophic cases, and literally within the first week of retention, we're already out looking for experts to cross the T's and dot the I's right off the bat, okay? And we're preparing.
That's what we like to hear.
Yes.
We
And
love to hear that.
Experts.com is where you can find the experts that lawyers like me need. Anyway, so we jump in and we immediately start looking for experts. So one of 2 things are going to happen. You're that expert. You're either coming in later in the game, which is 90% of the time, or you're coming in early and you're working the file early and you're working with that law firm to help position the file for settlement or for a maximum result at time at arbitration, mediation, and trial. So here's what you want to do under either situation. When you're contacted by a law firm, and hopefully you're contacted by, the lawyer that's trying the case. If not, you're going to position yourself to get in front of that lawyer. You want to ask a couple of key questions. You don't want to just send over a resume. You don't want to just say, yeah, I handle these types of cases. Ask open-ended questions. What's the goal here? What's the goal? What are we trying to accomplish with this particular file? What would you like to see happen to your client after a good settlement or a trial? What's our goal here? Is it money damages? Is it to fix a dangerous situation? Is it to change the law and move forward? What's the goal? I think when you ask those 2 questions, you're already setting yourself apart from most of the experts. Most of the experts, it's all about where they went to school. It's all about their qualifications. It's all about their experiences. It's all about what documents they need in order to render an expert opinion, as opposed to making it about the lawyer, the law firm, and the client. What are you looking to accomplish with this case? And then listen to the answer. And if you can add value to that answer, good. That's what I wanted to hear. That's exactly what I would be interested in helping you do also. Do you have a trial date? What are the deadlines? What are we looking at? And let the attorney talk. You've already started to develop rapport with that lawyer that most of the experts haven't even thought about. Because what happens is we get 10 CVs in, 10 phone messages in, there's very little conversation. Nobody's asking me these questions. And so the selection process with an expert is pretty mechanical and is predicated on some other issues also. Have we used that expert before? Have some friends of ours use that expert and refer them over to our firm? And we're going to talk about that at the end of the webinar on how to brand your expertise, your products and services. But right now it's the initial communication between you and the law firm. So ask those open-ended questions. And if it's early in the case and the attorney or law firm's not ready to formally retain you, one thing you can do is let that attorney know that you've got a busy schedule. And you understand that if the case settles the way they're explaining to you, they may not need you for deposition or trial. Having said that, if you're in high demand And what they may want to do is retain you for an initial consulting expert retention, and it's a low fee. It's $1,000. Okay. It's $500, whatever it is. Your normal rate may be $8,500, $10,000 just to get started, to review documents and render preliminary expert opinions and to let the attorney know what you need in discovery. Okay. We're putting that aside. What you want to do is try to create an initial relationship where, in exchange for this short single page retainer and a moderate retention fee, you're willing to put time aside to the best of your ability down the road to be available at trial. It's obviously subject to your calendar. This needs to be set forth in your retainer, and you're good to go. If the attorney has any quick questions because he or she or they think they're going to get this case settled, all they have to do is reach out and ping you. Send me a text, send me an email, give me a call. What you're doing is you're creating this initial top of mind relationship for a very low amount of money with very little friction. It's a simple retainer agreement. And if the case doesn't settle, and if the case continues to deposition, mediation, arbitration, trial, guess who that law firm is going to then follow up with to hire for the large retainer? It's going to be you. And you're going to be set up so that when that call or that email comes in, fantastic. I'm sorry we weren't able to get this case settled. What were some of the talking points or some of the issues that held things up? Listen to what they say. Then you come back with, all right, I'm going to send over an itemization of what type of discovery, what documents, what witnesses, what testimony I'm going to need in order to render the expert opinion that's going to help you win the case. I'll have my team send over my retainer agreement. Let's go ahead and get that digitally signed. Let's go ahead and get that initial deposit taken care of, and then you're off to the races. So my first tip is solidify that initial interaction with an initial basic moderate retainer consulting fee and agreement to introduce you to that firm. That's the first thing you want to do. If you haven't worked with the law firm before and you want to stand out above all the noise of the 10 other experts that are reaching out to that law firm to hopefully be retained, what you want to do is you want to spend a little time on Google and research this law firm, some other verdicts or settlements or judgments that they've had in this type of case, the type of case you're an expert in, and create an email or a blog post introducing, this is fantastic results, loved what you did in the XY case, the expert you had on the East Coast, and this is a West Coast case, that expert you had on the East Coast did a great job. I loved how she focused in on these 3 issues. In the case that I'm reading about in the paper that we're dealing with in Los Angeles, there are 2 additional issues I believe we need to dive deep in, make sure whoever you hire focuses in on those issues, and then get that communication out to the lawyer along with your CV and along with maybe other reported results that you've acquired or obtained as an expert witness. You're just setting yourself apart from everyone else.
And Mitch, I just want to clarify on that. Is it you wanted to do that follow-up? Was that at once the retainer was already in set, right? Or was this after that initial conversation?
The initial
when you follow up and that you've noted, you did a little research on the firm, you noticed, hey, great verdict. When did you want that communication to go out?
Day one.
Day one. Gotcha.
Yeah. It's, if you know more about me and my verdicts in similar cases, and you acknowledge those when you reach out to me, like I just described, and then give me the opportunity to start that relationship with you for a moderate dollar amount, especially if I don't think I'm going to trial on the case.
Mm-hmm.
Okay. Number one, I'm impressed that you took 15 minutes on Google to find this stuff. Number two, you already pointed out 2 or 3 issues that were important in those other cases that you're recommending I focus on in this case. You're giving me some free information. Number 3, you're letting me create this professional relationship for a very low dollar amount. And number 4, when I'm ready to hire you full time, it's game on. It's not going to be an issue. You're already a part of the file. Okay. Even if the attorney doesn't realize it, you are. That's just the way relationships work. On big cases, if there's a big tragedy, a building goes down, you're a premises liability expert, you've never worked with a law firm before, you can do the same thing but you need to initially reach out to that law firm, subject to your state's rules and regulations. You need to reach out to the law firm. This just happened. I'm expecting your firm to be lead counsel on this building, on this falling building case. And I want you to know that this is what we focus on. These are our past cases. This is how we can bring value to this particular case. If you're interested in having us involved, here we are, here are our results. That's a lot more effective than just an emailed resume, which is what we get most of the time, maybe a phone call with a message or an email. Take the time to sell yourself and stand out above the noise. That on the initial interaction between an expert and attorney, I think makes all the difference in the world. So that's how I would start the relationship.
And I like this. When we were preparing for this, Mitch, you had mentioned you thought that initial contact is where your experience with some experts was you've seen them be kind of weak in that initial. We're persuading at the time up, like you said, the persuasion to even use you to convert you to a client starts right there in that first contact. Maybe even before, as we'll talk at the end. But you'd had some weak experiences. Do you have any in mind that left you, without naming names, of course, but anything that had left you as boy, they look great on paper, but I just didn't get the right feeling from it?
Well, I don't even know if they look great on paper because I didn't spend the time to follow up and click and check out their CVs. So it's that bad. And what happens is when you just send a lawyer an email, hey, this is what I do. This is my area of expertise. Click here for my CV. That email gets dragged to a folder. It gets deleted. Very few lawyers, especially if they're busy and successful, are just going to open up a random email. All right. We've already got our expert databases. I already know I can go to experts.com. I'm not just going to waste my time with a random incoming email. So what you need to do is kind of set yourself apart. If you're an expert that is interested in getting more involved with a law firm that handles XYZ types of cases, do the research on the success that law firm's had with XYZ cases. And when you reach out to them, make it about them. Very impressed with the results that you've gotten. Loved how you handled the 123 Blueberry Street falling building case. It was interesting how you incorporated, the negligent inspection of the city 10 years ago into what actually happened 8 or 9 years later. And be specific and spend a little bit of time just really and correctly and from the heart praising the law firm's work and how impressed you are. And then come back. This is what we do. And this is why we're as excited as you are to get just and fair and equitable results for your clients as you are. And we'd like to be a part of the team. Approach it like a relationship. If all you do is talk about yourself, nobody else is going to be interested in what you have to say. I think the same thing applies to expert witnesses during the initial interaction. Now, don't get me wrong. Some of the best experts I've ever seen in court are the same experts we're talking about. Okay. But it just takes too much work to find out who these individuals are. So make it easy for the lawyer, ask open-ended questions, find out what they're looking for, and be up to speed on their history and their results. And that's how you build a relationship with the firm. So that's one way to start off the relationship. And I think that's a really good way that most experts aren't doing, but could be doing, Nick, to get more retentions and at the end of the year, more business.
And I want to just add, and I think that's great. I agree with, of course, we have been in agreement on this issue beyond just our expert witnessing, but professionally, we've talked about this many times. But for the expert witness specifically, is that first pitch discoverable? Is that something, or is that first pitch to the attorney? I feel like that's a worthwhile question for some of our.
It is, but not for a reason everyone's asking in the chat. And I just glanced at the chat and like, oh my goodness, everyone, I want to answer every one of your questions. Here's why that first interaction needs to be discoverable and why it should be discoverable. The earlier a lawyer retains an expert witness in the case, the more it appears that law firm is on top of things. Okay, let's say you have a case that you've litigated for 2.5 years and you're finally in trial. And a good defense attorney or a good plaintiff's attorney on the witness stand is going to ask the expert witness for the other side, when were you first contacted, or when did the first interaction take place between you and the XYZ law firm?
Okay.
Because you're hoping the answer is 30 days before trial. And all they're relying upon is what that law firm gave them for information. And they aren't prepared, and they're simply a hired gun. When that answer is, well, let me see, and we'll talk about this, how to handle this at trial, everybody. But if the answer is, if you're asking me when, to answer your question, little Johnny was struck by the distracted driver on January 5th, 2019, if I'm not mistaken, counsel, is that correct? And the attorney is going to go, that's the correct date, although we're disputing liability. Well, that's fine. But if that was the date of the wrongful death, we were contacted 3 days later by the plaintiff's attorney, who then told me they wanted to make sure that they understood all of the different dynamics, both legal, factual, and regulatory, involving the control and management of that intersection. So about a week after the wrongful death. Okay. That type of answer is so much more important, I think, than 2 weeks before trial. And the key is, if you remember what I said earlier, that initial preliminary retention, listen, we're going to retain you as a consulting expert witness. We may or may not use you. In return, you're going to do your best to have whatever trial date ends up being assigned, because that hasn't even happened yet, but we're looking about a year out. You're going to use your best efforts to be available at trial. And we're going to sign that one-page retainer agreement and pay you a preliminary $1,000 retention fee, and we're good to go. What's just happened, and if you explain this to the lawyer, they just created a scenario at time of trial 2 years later where they've actually retained a consulting expert. It's probably going to be you on the stand immediately after the incident took place. And that looks fantastic. That really gives the jury the impression that you're not just a hired gun. You were hired to help ascertain the facts, help establish what the law is that's applicable to these case facts. And you are an objective expert witness who's here to be a leader in the courtroom, to share the facts, your expert opinions. And that's why it's so darn important to get hired early. And if you explain this to the lawyers, a lot of them don't think this way. And once you say this, the light bulb goes on. They're like, all right, Nick, listen, let's go ahead and just, I'll DocuSign over, a preliminary agreement, or you send it over to me, we'll get it taken care of, and we're good to go.
Yeah, that's great. I never thought about it in that strategic sense.
Huge, huge.
I see the questions coming in, folks. We are going to get to those. We'll leave plenty of time for Q&A. I'm sorry, Mitch. I don't mean to stop the, you're on a roll. So I'm going to let you go into what you got next.
So we have some different talking points. And oh my goodness, I'm looking at all these questions here. These are awesome. And I want everyone to know, Nick, I think the world of you and Experts.com. And if anyone has questions that we haven't answered, just ping me. Yeah, and I'd be happy to answer them, email me, whatever it is. So we talked about the initial retention approaches during the first part of today's webinar. We're going to roll over to how to make an impact at the expert deposition, how to really make things pop so that you can maximize settlement or maximize what happens at trial. We're then going to roll over to how to keep the jury on the edge of their seats in the courtroom by how you present your expert testimony. And then we're going to finish up with different ways to stay top of mind in the lawyer's mind after the case is done. And then also different ways experts can market and brand their practice. So the next thing I want to talk about is you've been retained and depositions are being set. Before walking into the deposition, you want to make sure you've got some type of list that you have already checked off with the law firm that's hired you. In other words, you've let that law firm know, and it might be part of your retention agreement that you entered into 6 or 8 months ago. These are the 10 things I need, whether it's a witness's testimony, whether it's documents, document production, whatever you need to render a full and complete expert opinion at the time of the deposition or trial. Make sure that you're on top of getting all of that information before you're expected to raise your hand and give testimony under oath, okay? And if that hasn't happened because the law firm's dropped the ball or defense counsel's not cooperating during the discovery process, think about asking the attorney that hires you to, continue your deposition until you get this information and bring them, whatever it might be. It's
Right.
just important because I don't like to see expert witnesses get caught up under oath at the first opportunity, which is usually a deposition, and not have everything that expert needs. So that's number one. Number two, when you do come into a deposition, be ready to go. Ask the lawyer who hired you before you go in, what are the 2 or 3 questions you're expecting me, the defense attorney, to ask to throw me off my game or to help highlight the weak parts of this case? You don't want to find out about those in the middle of a 6-hour deposition when everyone's tired. You're thinking about lunch, and all of a sudden defense counsel throws you with a curveball, and it's a well-thrown curveball by Nolan Ryan, and you weren't expecting it. And frankly, you're not ready to handle it. You don't want to allow that to happen. So by preparing before the deposition takes place, you can avoid these situations from happening. Have your lawyer explain to you what the issues are so you can get ready to offer expert opinions or maybe even suggestions on what additional discovery might be necessary to deal with those issues that the defense attorney is going to bring up. Anyway, the deposition starting, I think it's critically important for experts to learn how to command the room, learn how to take command of the room. And what I'm saying is learn the difference between being tough on issues and kind to people. When you walk into a deposition room, think of it as a process. Walk in, and I know this is basic 101, human interaction, but it's critically important. Walk in tall with your shoulders back, your chin up, reach over, introduce yourself to opposing counsel with an appropriate handshake or knuckle bump or whatever it is.
Might be a knuckle bump these
whatever
days.
it is, right? Or maybe
Right.
it's just a hello, a confident hello. I'm going to respect your social space right now because of COVID. But show confidence in the deposition room. And if you're not good at doing that, work on it. I mean, I'm just not going to, I'm not going to sugarcoat this. It's critically important because what happens as an attorney is when we have experts in our depositions, even supposing experts, we immediately pick up on whether he, she, or they is confident in who they are, in their expertise, and what they're testifying to. So sometimes you have to realize that the attorneys in the room are nervous, and that they don't seem like they're nervous. You know why? Because they've done this a million times and they're acting. All right, they're channeling their nerves over here, and they're coming across like they know what they're talking about. They've got a solid case. They're hoping the other lawyer doesn't bring up certain issues or doesn't produce certain documents. And there's a lot of poker playing going on. And good lawyers just learn how to compartmentalize all that. And they're going to treat you like gold. They're going to treat you like respect. And if you do the same back to them, you can have a very worthwhile, meaningful deposition. So that's the first thing, is do what you need to do. Take acting classes, read the right books, talk to friends of yours, but just learn how to come across as being comfortable and confident. Look everyone directly in the eye when you're speaking. Don't let anybody strong arm you into saying something that you don't believe in or just is inappropriate.
This is them acting with the authority that they have as an expert, and then the perception of the confidence that they
Critically
have.
important. Perception's everything.
Everything.
Perception and expertise, put them
right.
together, right?
Right.
But the good experts are the ones that are confident on the outside, even if they're a little nervous on the inside, and obviously know their craft. They know what they're talking about. Okay.
Right.
The next thing is, when you're in depositions, you already know by talking with your lawyer what the issues are, what your expected expert testimony is going to be, and you want to make sure that you cover all of those talking points. If there's written documentation, if there are periodicals or books, if there's something out there that either supports or contradicts something that you feel deeply about as an expert witness, you want to know about all of this ahead of time. Oftentimes, what I've found is while you're answering questions and you're sharing your expertise, you share the strong points first, you build rapport, you've built that credibility. Now, if there is a weak point in the case that your attorneys talk to you about, or even the defense attorney or plaintiff's attorneys talk to you about earlier in the deposition, it's out there, everybody knows about it. There comes a point in time where you want to talk to the attorney who hires you. At some point in my deposition, I want to unilaterally ring this bell before the other side does, is what I'm getting at.
Gotcha.
We do this at trial all the time, but if you can ring the bell first, you can control how you hold the hammer, you can control how hard you hit that bell, and you can control what facts and what stories you use to help complement or minimize that bell that's being rung. And so the next transition during a deposition is learning how to answer questions using good persuasive storytelling techniques. And I think it's important. And so it's one thing to answer a question yes or no. It's another thing, which I like my experts to do, by the way. Okay. But you're going to want to pepper in every now and then a response that is a little bit longer. It uses storytelling techniques so that you can emphasize the point. And one way you can emphasize points, not only in deposition, but mediation, arbitration, and trials, is by using metaphors. And I think when you answer questions using metaphors, which have been a game changer in my career, with everything else we've just talked about, everyone's going to be leaving the deposition with a new mindset. Like, Nick Richling, that expert witness, I don't want him on the stand. He's good. Or I don't want a jury to hear what he just testified to on the fly, because between now and trial, his lawyer picked up on how effective that was, and they're going to fine tune that. This is not going to play well for us. So, for example, let's say we're talking about what's relevant today. Let's talk about
distracted driving. Any of those.
Yeah. Let's talk about distracted driving. So distracted driving, X amount of people are killed each year by distracted driving. And in this case, Mrs. Jones' daughter was tragically killed because of a distracted driver. It's one thing to say distracted driving is dangerous. It's another thing for an expert to say, yes, in my expert opinion, operating a motor vehicle with one of these in your hand is distracted driving, and it not only places your health and safety at risk, but those of others. I mean, that's an answer right there. Or you can say something like, a lot of people don't realize that distracted driving kills. And just like it did in this case, if you're looking down at your smartphone for 3 to 5 seconds, which is the average time it takes to look at a text, at 55 miles an hour, that's like traveling the length of a football field blindfolded. Nothing good's going to happen in this situation. And in fact, in this case, it didn't. Little Susie was killed because of Mr. Jones's distracted driving. So you can kind of incorporate metaphors into your expert testimony. And those metaphors play well, not only in depositions, but they play well when it comes to trials. If you are representing, right now, the big topic, is COVID-19, vaccinations, deaths, things like this. Well, the reality is, according to the CDC, about 2,000 people are dying a day because of COVID. Okay. So let's say the issue has to do with somebody allowing somebody else into an unsafe area that resulted in a death.
Right.
And you could talk about, well, in my opinion, as a physician, as an ER doctor, as an infectious disease expert, 2,000 people a day are dying because of COVID. And so it was, in my opinion, unsafe to allow this person in that wasn't vaccinated, whatever. Or you could say something like this. You could say, a lot of people don't realize that the number of people dying in the United States from COVID each day is identical to 8 fully loaded 747 jet airliners crashing and killing everyone each and every day. Those are the numbers that we're talking about. And so for that reason, in my expert opinion, walking in without a mask, unvaccinated, knowing you're infected into a restaurant, infecting the staff was, an unsafe step, a negligent act, whatever it might be, depending on the codes.
I like this, Mitch. We talked about this, and I'll give you a second if you want to grab a drink of water there. I know you've been going. I like these metaphors. You use them regularly in many communications, and I think it's important. We had this question from somebody before the webinar started: are we teaching experts to persuade as though we're teaching them to argue in this webinar? And that's not what we're doing, because that's really the role of the attorney to make the argument. But this is persuading with clarity, which is the title of our webinar. And what you're doing with the metaphor is you're actually you're setting it up in a storytelling fashion that allows the jury or opposing counsel or whomever to just understand it in a little different point of view, right? It just adds some, almost a visual to it. When you say the 747s, I picture that, and that impacts how I see the number of people who may perish from this. Or when you talk about the number of football fields being blindfolded, okay, I'm envisioning that now, and it just adds a little bit of clarity.
I think it adds a lot of clarity. A lot of clarity.
Yeah.
It's persuasion. It's
rather than just saying this is the number of, you go 55 miles an hour and you would travel 600 yards in 3 seconds.
So it's critically important to learn how to be persuasive. And I'm looking at the chat, and, with this conversation you and I are having, this is kind of like next level communications between experts and the attorneys. Everything that we would normally do as experts, as attorneys, state bar rules, regulations, positioning the file for discovery, all of that still comes into play. And when I see, I just need to come back to, a couple of different questions.
Sure.
I don't want to know the goal. I am there to examine the evidence regardless of the expectation of the outcome, and that's a great comment. I'm not talking about the goal of what is it you want me to say under oath to win the case. My question is, I always want my experts to know why I've taken the case. I'm taking this case because my family's 2 kids were killed by a distracted driver, and I want to find justice. That's my goal. See, that response is simply, my why. Why I'm involved in this case. My emotional touch points.
Right.
And so as an expert, if you know where I'm coming from, then you can position your conversation and what's in the retainer and what information you need to take into consideration my why with why I took the case. You want to know why a law firm has decided to take a case and change the law or hold a wrongdoer accountable. Oh my goodness, if you don't care about that, then you're never going to be one of our expert witnesses. I mean, this is really important. So You've got to make this about the attorney, and you've got to make this about the cause and not about you. And I think smart experts are really good at doing that, while also paying attention to what's discoverable. And when I talk about, I want to know 3 or 4 of the issues that you feel are going to be a challenge for us. That's probably going to happen during an oral conversation early on in the case. I'm not talking about creating a list of discoverable emails that the other side's going to get. I'm also not talking about being evasive or hiding the ball. What I'm talking about is doing what you need to do under your local, state, and federal rules to get the information that you need to provide the best expert testimony available. And because we're talking about getting that law firm to push the button to retain you, let me just fall back to develop rapport, be interested in the lawyer in the file. Okay, this isn't a mechanical situation. Oftentimes with good lawyers, it's personal. If you can tap into why it's personal, that's why you're going to be the lawyer or the expert that's retained. If you're not comfortable with doing that, then don't do it. But you're probably leaving retentions on the table with some pretty big firms, because that does matter to us. And that's why I'm on the show today, to tell you exactly where we're coming from as trial lawyers. Hey, let's move over to, go ahead.
Let's move. I was just going to say, we've been going about 40 minutes. We've got just really 2 more topics and then kind of a wrap up here. You want to talk about creating anticipation and drama at trial?
Absolutely. And so let me get rid of my screen here. And great questions, you guys. And
And
you
we
know,
will
just want to keep
we'll
everything
spend
in
some time
context.
on
Yeah.
this. Yep.
So here's the thing. You're ready to go. You've got all the information you need to offer your expert testimony. Your deposition went well. You did the things we're talking about. Now you're on the stand at time of trial, and you know it's time to offer expert testimony at time of trial. One of the approaches that works really well for my experts, and I've seen other lawyers do this too, it's a three-prong approach to an expert answering a question. And what I mean by this is oftentimes we have the back and forth, yes and no. Can you describe? What are your thoughts? Tell me more about. And a good expert will connect with the jury while answering the question. A good expert will make eye contact with the jury, come back to you, look over at the jury, explain the process, almost like a good respected college professor. So you respect the individual. That individual is genuinely trying to explain or add value, so the jury can make a correct factual decision. And oftentimes it's what we've all experienced in court. But if you want to raise the bar and take things to the next level, if there's a question that can be answered yes or no, what you want to do is break it down into a three-part process in front of the jury. Instead of just asking that yes or no question, what you want to do is, let's just say, was the light red or green? Okay. All right. So I could ask Nick, if Nick's our expert. So Mr. Rishwain, based upon the evidence, based upon your research, based upon the documents presented, based upon everything you know in this case that we've been talking about for the last 20 minutes, in your expert opinion, what color was the light? Give me an answer.
It's a red light.
Red light. And let's talk about that just for a second. Then I step up and I walk over to a blow up, a trial exhibit. And this is something that Nick knows that I'm going to be doing. And it's of an intersection. There's 2 or 3 different lights at that intersection. I want to make sure we're talking about the same red light. Nick knows that we are. I know that we are. But I want to use this as an opportunity to highlight that light was red. Your Honor, I'd like permission for Mr. Rishwain to approach the blown up trial document or use the apparatus in front of him to show us on the screen with these 3 lights at the intersection, which light is he referring to as the light that was red? So now the jury is looking at this picture. There's 3 lights, a stop sign. Once again, you come around and you circle the light that was red. So now the jury is hearing about that red light twice. Okay. The next thing is I'll come back to either deposition testimony or something you said earlier where it may have been possible to misconstrue something that you said regarding the intersection of the light. And so, Mr. Rishwain, when you testified 15 minutes ago in front of this jury that the light was red, in fact, you showed us which light on the overhead here, and thank you for doing that. Let me ask you a question. Is there any possibility that the light that you testified to was red was actually the light the defendant's referring to at another intersection 200 feet down the street? Are we talking about that light or the light above and the one you shared in front of the jury? No, I'm talking about the light that I testified. So we bring it up 3 times. And sometimes on these issues, everyone, you can ask the expert a question from the stand. You can then use demonstrative evidence to reinforce and actually ask that question again. It's not asked and answered because it's a different question. And then you can come back before you move on to the next topic by tying it into the original question. You can do this 2 or 3 times with an expert. And if you do it carefully and correctly, you're gonna hammer home and win that issue. And if you save this approach for the important issues, then you're going to make an impact with the jury, and they're going to talk about that back in the jury deliberation room. If Nick, the expert, is explaining this process, like I said, using storytelling techniques. So when Nick, I'm going to share with you guys 5 steps, steps to persuasively sharing your expert opinion in court using the example we just gave. So when Nick comes off the witness stand and walks over to to the blow up trial exhibit, which is probably what I do, because now it makes Nick a human being standing in front of the jury instead of somebody just sitting up on the jury in the jury on the witness stand.
Right.
And I want you to be, so I purposely probably wouldn't use a PowerPoint to do this. So you walk over with a marker and I ask you to mark where this is. And while you're doing that, I'm going to run through 5 steps with my expert witnesses. And the reason we're sharing this on this expert witness webinar is that most lawyers aren't doing this. So as an expert witness, you can talk to the lawyer about, listen, when you ask me these questions, you might want to run through them in these 5 steps. I think it's going to help.
Right.
You help a lawyer get a good verdict, that lawyer is going to remember you, and you're going to be that lawyer's go-to person for the next case and probably every case thereafter.
So what are those 5 steps?
The 5 steps are, number 1, you got to state the problem. So as you're walking over to this blow up, now the red light, this is you talking. Now the red light that you asked me about, the problem is which one of these 3 overhead lights, and we know it's not the stop sign, which one of these 3 overhead lights is the red light that we're talking about. And it wasn't hard to determine because of the police department records and 3 witnesses, and you circle it, right? And the reason it's important, the second step is you want to agitate the problem. The reason we need to know which one of these lights was red is because if we're wrong and it was one of these 2 other lights, then that would change the entire accident reconstruction approach to this particular case. So it's super important that we understand which one of these lights was red. I mean, let's just say that's the reason you're here. They think it was green. We know it was red. So
we're stating the problem, then we're agitating it.
You're agitating the problem, number 2, and the expert witness can be doing this, or the lawyer can do this with a couple of questions. Number 3, you want to state a clear and concise solution. So understanding all of that, because of the police reports, 3 expert witnesses, city records, whatever it might be, the defendant's own testimony, you circle it. This is the red light. This is the conclusion. It's this light right here that we need to pay attention to. So number 1, state the problem. Number 2, agitate the problem. Number 3, state the conclusion. Number 4, how does that conclusion help your audience, in this case, the jury, with that finding? It's important that we have now determined this is the red light, because this is the red light that controlled the direction of travel for the defendant's vehicle. If the defendant ran through this red light, in my expert opinion, now you're looking over at the jury, he violated, the ABC code of the traffic code. And I'll let Mr. Jackson explain the ramifications of that. Okay, that's number 4, is how does that apply to your audience? And then number 5, some kind of call to action. So in court, an expert's call to action would be, Mr. Jackson, is there anything else you'd like me to do with this exhibit? I think I've shared all I can, that this is the light that was red, and the call to action is, and I think the jury has the information that it needs, unless you have any other questions. And of course I will. Mr. Rishwain, I actually do have a few more questions. Why don't you take the stand and let's continue? So those are the 5 steps that I think work really well in trial. Sometimes you can do it from the witness stand. Oftentimes you want to incorporate storytelling techniques into each of the 5 steps. Oftentimes good expert witness will incorporate metaphors into one or more of these 5 steps. Sometimes steps 1 and 2 are fast. Steps 3 and 4 may take a little bit more time. I mean, 5 minutes, 20 minutes. It just kind of depends on the flow of the case and on the issues that we're talking about. But that 5-step process, I think, works really, really well. Most experts don't play in that sandbox. Most lawyers aren't aware of it. But if you're that expert and you're that attorney that are using these 5-step processes, and the lawyer picks up on it and then also plays around with those 5 steps in closing arguments and walks, listen, you all watched Mr. Rishwain testify from the stand, walk over in front of he took the time to walk over in front of you.
All right.
And he took 15 minutes to show you why this is the red light and the importance of making sure we had the red light. And I'm glad he did that. And I'm sure you are too. And when you go back into the jury deliberation room, I want you to talk about that, because guess what? Their expert didn't do that. Their expert wasn't sure which light it was. As a matter of fact, their expert was paid $16,000 $500 to come up with 16,500 reasons to offer the testimony that they
That's-
gave in the case.
That would be
Boom.
you, the attorney, saying that, not our expert.
Closing argument.
Yeah,
Closing argument.
yeah. But I see what you're saying in that space. This goes back to the rapport that you've been building from that initial contact. That if you do that call to action, if the expert does that call to action to you to have, Mr. Jackson, do you have more questions? That's almost like just passing the ball, right? Okay, we've now got this rapport, so I see where the attorney's going and I see where he'd like me to go in order to have a little bit better rapport, a little bit better flow. Is that seems to be what you're describing to me? It does.
The best trials are stories that are told.
Yeah.
Where, there's a hero and a victim and a challenge and an outcome that we can all root for.
Right.
And while you were speaking, Nick, I'm kind of glancing through a lot of the comments and, understand everybody. Absolutely. Once you're retained, do your thing, bill what you should be billing, get your retainer signed, be objective, be honest, be truthful. A lot of what we talked about at the very beginning of this webinar was getting retained in the first place, getting your foot in the door, getting that lawyer to respond to you so that you can do your magic.
Right.
I'm looking.
This is keeping in mind, and let me get you to keeping the relationship strong after the verdict, and then we'll just hit questions if you'd like.
Yeah, absolutely.
Let's do that.
So once the verdict comes in and the case is done, what I've noticed is good lawyers, and this has happened with us over the years, you start to forget, what was the name of that expert? What was the name of his or her company? And that's what we get busy. Everybody gets busy. Even though we use databases, we can get a little bit busy. So I think what you want to do as an expert is, even if you're not retained from the very beginning, okay, that the firm went with somebody else, maybe somebody that they knew, somebody that was recommended to them, but you liked that attorney, they liked, what they saw and heard from you.
Mm-hmm.
You want to stay top of mind, even if you weren't retained. At the end of a case, if you were the expert witness, what you want to do is circle back in 3 to 4 times a year, make contact, touch that law firm. And what I'm talking about is in a way that other experts aren't doing this. For example, you might create a short video. Just in this case, Nick would reach out to me. Hey, Mitch, it's Nick Rishwain. Just wanted to say great job on that XYZ case last week. I didn't think anybody would win that thing. I don't know the facts, but I just wanted to take a second and say, awesome job, and keep protecting the little guy. It's something like that, right?
So you're following their career and
follow their career, follow their results, and reach out with a short text or an email when you can. If you see that they have a case that you can add value to, but let's just say you're not interested in being retained or it's just not something you want to do, you can still send over a link to an online article explaining that process or that new argument or that new approach to, XYZ. It's a matter of just staying connected with the law firm. Also, if you're comfortable with social media, and I am, I love it when my past clients, witnesses, experts, after a case is done, I like it when I see little comments on social media. Hey, Mitch, looks like a great baseball game. It looks like you enjoyed your paddleboard down at Dana Point Harbor. It's just a little note. It doesn't say, hey, Mitch, this is Nick Rishwain, your expert witness at the XY. It's
right.
Mitch, looks like a fun morning of paddleboarding. And I know it's you. Mm-hmm. And that's a great way of staying top of mind in a very human to human fashion. And guess what? You start to build relationships. You start to build friendships with a lot of people you work with, whether it's opposing counsel, whether it's an expert witness. I think that's critically important. After the case is done, share news links that relate to the type of law that law firm's practicing, ideas and trending topics, whether it's an email, whether it's a BombBomb video, BombBomb, BOMB, it allows you to send little short video emails into someone else's inbox. It's better than email.
Yeah, it's
whether-
a really fantastic, and folks, it's a really fantastic tool. I've employed it a little bit, but Mitch does it. And hey, great chatting with you today. And then he shoots a follow-up, and you just click on the video and it says hello. It's really cool and really makes the person feel special. And then you get great tracking out of it. So if you're following up with that law firm that, hey, how'd that heard about the verdict? Great. It was a real pleasure to work with you on that, rather than having it just in text. You send it in a small video via email. So very cool, very memorable.
And it helps you stand out. And when you're doing all of these things, keep these three components in mind. We're talking about branding now, and just make whatever you're doing with that touch with the law firm, if you can, it should be appropriately entertaining. Everybody likes to be entertained, and just make it appropriately entertaining. Number one. Number two, make it unique, make it different. So it's not just an email. It's just not a snail mail CV. It's something else that you're doing to stay top of mind. And number three, if it's on social media, make it shareable. Make it something where if you do something that's pretty impressive as an expert, that law firm's going to know about it and share it with another law firm who may be looking for an expert just like you to help them with their case. Make it easy for the law firms you develop relationships with to share your expertise with other law firms. Yeah. That's the easiest way to get an expert gig. And I think a lot of experts drop the ball on that. They don't think that way. And so hopefully after today's webinar, they will.
Yeah, I think so. And we'll probably, in some of these question and answers here, we'll cover that kind of persuading them to contact you in the first place as we do some Q&A. But the one other trick that you mentioned here, Mitch, that I've talked to others about is even the email, even if it's not the case that you're worried about, if you're the traffic engineer who saw the autonomous vehicle crash, and you find that firm from Southern California that you worked with before on some sort of a auto accident. If you worked on that before with them, and maybe you're interested in the autonomous vehicle crash, maybe you're not, but maybe telling them, hey, you know what? I saw you're up on this, you're working this case, and here's something I think you should think about. In this case, it's just some of the issues having to deal with autonomous vehicles. It's from the engineering journal. Just take a look at it, and you're not even asking them to contact you. It's just sharing a piece of information.
I love that, Nick. Adding value, sharing information, and just being useful. If you're hustling and you're trying to get somebody to hire you, that's kind of a turnoff. But if you're adding value, you're trying to be a part of this winning program, this winning process, whether it's this case or the next 10 cases, that's where lawyers will pay attention to what's going on. And Great. Those are the types of experts good lawyers want to surround themselves with.
Great. So we've got some questions from folks. Several of them are coming from me, but they're not really me. So apologies on that.
I want to say hi to Nabil real quick. I just noticed that he's here.
Yeah, he's here. Yeah, thanks.
It's good to see you, Nabil.
So the kind of first question here is, how does the expert deal with the lawyer or the firm that retains multiple experts in the same field with the intent to simply prevent them from working for opponents? That's a good question. This is the expert shopping, essentially.
It is. That's interesting. I think what has to happen is you need to set yourself up, in my opinion, and you tell me whether or not this fixes the problem, Nick. When someone wants to hire you as an expert witness, they need to sign your retainer agreement and they need to pay your retainer. And in that retainer agreement, that dictates the terms and conditions between you and that law firm. So I think you can plan ahead in your retainers, maybe modify the retainer a little bit and talk about, listen, this is what I'm agreeing to do. This is the payment schedule. It's non-refundable. It's non-negotiable. I mean, whatever it may be. And I think that's about as good as you can get when it comes to protecting your business interest in these types of cases. If someone wants to pay you full boat to pull you out of the picture, and they do that, and they can do that subject to their state bar rules and regulations, then there's not much you can do about that other than never do business with that law firm again.
Yeah, and make sure that you get the retainer,
Get paid up front.
Get paid up front. Yeah, thanks, Mitch. Gary asks, and this is a little longer one, what type and how many questions from the lawyer to the expert do you think are acceptable during the first vetting interview? He's had attorneys grill him for about an hour on all possible areas that could be researched technically during the first interview. And he said it feels like a lot of free consulting.
It is. It is. And so I think what you'll find is it's how you position yourself during that initial interaction. As we talked about earlier, if you come in, if let's just say they reach out to you, are they reaching out to you to hire you? Are they reaching out to you to pick your brain for free for an hour? And I think what you need to do is position the conversation. This is something that we're comfortable with getting involved with. We've seen the news reports. We need to confirm the facts. I'd love to move forward on this matter. If you're serious about getting us involved, let me email over or DocuSign over our retainer agreement along with the retainer, and we can take it from there. The good lawyers understand that they need to retain experts before they get their expert opinions, before they can designate you as an expert witness in the case and file that with the court. Yes, there are lawyers out there that try to get free input from experts without paying for it under the situation that Gary just suggested. And once again, after 5 or 10 minutes, you need to have a 2 to 3 sentence spiel set up. Great questions. These are important, critical questions that you need answered to get this case won. And just let me know what's the best email address for me to send over our retainer for you to review so that we can dive deeper to get these questions answered. I think that's the best way to do it. You've got to draw a line in the sand, and even attorneys do this. That's the way I roll. It's you got to have enough respect for who you are and what you do to draw a line in the sand and say, listen, I'd love to help you, but this is what we need to do next. If you don't do that, they're going to keep asking questions.
Yeah, they'll keep trying to kind of bulldoze right over you,
even if it's innocent.
Yeah.
See, a lot of times lawyers don't realize this. They've got pleasant personalities. Oh, wow. Okay. Well, let me ask you. So you got to play that by ear. If it's a huge firm that has a bunch of big cases, maybe it's an hour's worth of your time for marketing and branding. Maybe it's worth your time to do this, but you don't want to have it happen more than once. So
Right.
Great question, Gary.
Yep. And thanks, folks, for all these. There's a lot of questions in here. We're going to try and get to as many as possible. If you like one over another, please give it a thumbs up and help folks. If one's already a question you asked, you can upvote it and we can get to more. Michael asks, are there possible discovery problems down the road by being so specific in an initial written contract?
So I'm not sure I understand Michael's question. I think that the best experts use detailed retainer agreements, expert agreements. You want to have everything in writing. I think everybody expects that. The lawyers have written agreements with their clients. The lawyers have written agreements oftentimes with different third-party agencies that help us with equipment at trial. You having a detailed written agreement is important. Also, I think a properly written agreement with the law firm is objective in nature. It's written in a way where you're not promising anything other than to use your best efforts to review the facts, the evidence, and the circumstances to render an expert opinion. Put that in writing and you have nothing to worry about.
Okay. I think Marissa asked this question in regards to too many questions might bring in a bias. Was that during the deposition, Marissa, where the attorney was kind of pulling you through the five or trial where we were going through the 5-step process?
Too many bad questions can destroy a case. There's never enough good questions. And so let's whatever the issue is, whether it's that initial retention, getting ready for a deposition, participating in the trial process, or that post-trial victory, Zoom lunch, let's stay in touch, whatever it may be, the quality of the questions that you ask as an expert witness to a lawyer will dictate the direction that relationship takes in the future. So think about asking several open-ended questions that allow the lawyer to share his or her success, his or her concerns with the case, and give you direction, just like a doctor would with a patient. Nick, tell me more about this chest pain. Is it radiating down your arms? Is it Is it gravitating towards, a headache? Is it down in your right side? There's nothing wrong with good questions that allow you to then develop the appropriate expert opinions.
Excellent. And Catherine had asked this, and I think you touched on this. She had mentioned, I don't want to know the goal from the attorney. So you had talked about getting the expert kind of in the why of why you're doing it. She says, I don't want to know the goal. I'm there to examine the evidence regardless of the expectation of the outcome. And this is what I would tell most experts, is that the objectivity. So how do you balance that with your kind of?
Sure. One doesn't exclude the other.
Okay.
In other words, we want you to examine the evidence regardless of the expectation of the outcome. Absolutely. A good expert's going to do that based upon the facts and the evidence. Having said that, you need to know why you're part of this case. You need to know why you're being hired. You need to know why you're being asked to take the witness stand. And oftentimes there's a why to the case. Understanding the why we're all here, why this family is bringing this action, doesn't have anything to do with your objective expert findings. In fact, it gives you more context to why you're there in the first place. So I would encourage you to, not do both, because I think you'll come across as a better expert witness. Excellent. I don't want an expert witness that's not interested in the case. I'm going to be honest with you. It's a big deal. And if you're not interested in the case, I'll find 10 that are. Good to know.
Okay. How do you keep the judge or jury's eyes from glazing over when you have to explain technical methodology? They're important, but their boring data is used in the methodology. It's a great question, one we hear a lot from experts.
It is. I think using demonstrative evidence, using exhibits, incorporating metaphors like we talked about earlier into the discussion. If you're talking about a complicated procedure, maybe, look, this is complicated stuff, ladies and gentlemen of the jury. I get it. But you know what? When you get up in the morning and you flip the switch to the light on your wall and the lights come on, it's pretty simple, right? You just flip the switch. You don't think about where this electricity is being generated offshore, how it's being wired into the city, how it's coming into your building, how it's being regulated in the wattage, so that when you flip that light, the lights come on. You're looking for a simple process. Oftentimes, good experts can simplify and dumb down the process so that the jury is like, okay, now that I know how the lights come on, let's dive a little bit deeper into the details. I want to know how generators work and how that electricity is transferred from offshore into the city. So I would suggest use an example to keep it interesting, use metaphors to keep the jurors at the edge of their seats. But sometimes you've got to make the transcript. You've got to present the evidence to protect the verdict on appeal. And so you got to do what you got to do. And if you have the kind of expert testimony where for 3 hours, everyone's sitting there listening to something that nobody wants to listen to, you better get it on the record. And for the trial lawyers out there, what you want to do is you want to follow that up with a witness or a situation at trial that they're going to remember, they're going to talk about. Okay, you want to bring it back. You're in control. You're the leader in that courtroom. So if everyone's sound asleep, including the judge, you need to do something about it. And so you need to bring that case back around, wake it up, and start moving forward. But if you have to establish the transcript for appeal, then that's what you have to do.
Yeah, I think to add to this, Mitch, what that question was, where metaphors could certainly help in describing some of that, going through some of that data or that methodology that may need
Absolutely.
to be just to kind of mix up that some of the more difficult information.
Nick, real quick, we had a wrongful death case where the opposing expert on the dynamics of how the death took place, it was a carotid chokehold, much like what you see on television.
Mm-hmm.
I don't need to go into the details, but he was so boring explaining the medical behind, how this carotid chokehold couldn't possibly have caused the death. And it was very boring to hear. Our expert came in and I felt like for 45 minutes, we were all basically entertained. I mean, it was dynamic, outgoing, made eye contact, covered the science behind it, the physics behind it, used some equations, but it was fascinating. It was almost like a 60 minutes. So I actually think some of the more technical stuff can be explained in a way that's somewhat engaging and entertaining. You just got to have the right expert to do it. And if it's not, and if it's someone that's had to do this 10 times and you put the jury to sleep 10 times in a row, you know what you're talking about, but maybe change your approach, change your presentation, and change things up, and you might get a different result.
Excellent. Somebody asks, what would you consider a small initial retainer?
Well, as to what we were talking about, in other words, listen, it allows you to start that relationship, right?
Okay.
And it may never be used again. You may never be used again as an expert, but it's just something to get your foot in the door. It could be $500. It could be $1,000. It depends on the type of case. $1,000 retainer on a biomechanical engineer on a small traffic collision case, fine. On a complicated multi-million-dollar case, maybe it's, a $5,000 retainer, $10,000. I mean, whatever works for you, the facts in that type of case. All I was trying to get across is if you can create some type of contractual relationship between you and the law firm early in the case, if for no other reason to allow you to be able to say, yeah, I was retained 4 days after the collision.
Yeah.
Okay. That's the most important thing there.
And I will add one thing to that, Mitch, which I think is great strategically, but for my customers, I would say you want to see how serious they are. So requesting that retainer adds value to your service. The value of your service. So sometimes you'll get people who, as Gary had asked earlier, who really want to get out that free stuff. So I think it is important for you to require a retainer. Oftentimes I'll recommend something in the area of about, say, 5 hours of work, just so that you know that the attorney or the law firm is serious about using your services.
And let's be clear. When we talk about retainers, I am a strong proponent. If you're going to be an expert witness, build a career on not being the least expensive, but build your career on being the premium expert witness in your field, in your location on that topic. I strongly encourage bill top level numbers, top level retainer fees, position yourself for the long term as an expert instead of the least expensive in town. And I think that's how you create a career that's meaningful as an expert witness. A great book that's out, it's in its 4th, 5th, or 6th edition, has to do with consulting, Nick, but it's very similar to being an expert witness. And it's Alan Weiss's $1 Million Consulting. If everyone here hasn't read that book, it's a blueprint to how to set up, in my opinion, a good, effective expert witness career. And Alan will tell you it's about, positioning yourself as a premium expert, building out your profiles at Expert.com in a way that maybe other experts, and I've been meaning to talk to you about this, Nick, other experts' profiles. If your profile looks like everyone else's, think about changing it up a little bit.
Yeah.
And I'm going to be doing that on mine. I'm listed at Experts.com, everybody, and for legal malpractice stuff, but change it up. And I think position yourself to be at the top of the list. That's what's important.
Yeah. Position yourself to be differentiated from others, I think, is a big part of what Mitch does through his consulting. You actually have 2 profiles with us, Mitch, your legal malpractice expert witness, but you also do consulting, and you have a consulting profile separating the 2 separate, you have more than 2 separate areas of expertise. And I think that's important. This is a good one, but how do you suggest developing a professional, comprehensive CV? Do you know of a good template I can use? How do you think about those CVs, Mitch, in developing?
Make sure your CV is different than everyone else's. Start off with the benefits that you offer that firm in the first top fold, 1/3. Okay. In other words, this is the value you bring to the table for this particular case. You can have that top 1/3 set up. So if you're sending it to my law firm on a wrongful death case, you've tweaked it and personalized it, maybe to the parties' names, maybe to the issues involved, whatever it might be, if it's a national type of issue, so that immediately I'm like, okay, here's somebody that understands what this particular case is all about, the why, and is sharing with me his, her, or their experience in the CV. That in and of itself is different. Number two, you want to keep the initial CV somewhat short with a link to maybe a website page where if I want to dive deeper, I can. So in addition to your snail mail CV that you can fax or attach as a PDF that's unique and different, offers benefits right off the top, there's also a blog post or a website page that I can go to, and you can keep both of these updated. And you want to make sure they're accurate. You want to presume the other side is looking at it and lining through every single thing that you've got up there. But for me, that's what really stands out. The other thing would be maybe incorporating that blog post or website version of your CV with a short 3-minute video or podcast interview about maybe a big case that you helped obtain a verdict for, maybe something that you're passionate about and why you've become an expert witness, protecting the little guy, holding the wrongdoers accountable, whatever it might be. Incorporate media into your digital CV, and that'll help you stand out.
Yeah, that's great. And I see Nabil is answering some of these questions. I want to get to this one because I think it's worth repeating. Somebody asked for that three-prong approach to answer a question in trial. And I want to say, I do want to say, Mitch added just brilliantly about adding a video. And there's a reason on our premium membership, you can actually embed a video. On Experts.com premium membership, you can embed a video in the description. Let them get to know you immediately from that first time they see that profile on Experts.com. So think about that. It's a great way. Have it on YouTube. We embed it right on your profile. Sorry, Mitch, the three-prong approach.
You know, I'm all into video, and make sure the video's done right. You know, you don't have to have it professionally done, but make sure it's decent lighting and it portrays how you want to be portrayed, right? Oftentimes you don't have a second chance to make a good first impression.
Sure.
So but videos are huge. Yeah. The three-prong approach is throughout the course of either a deposition or a trial, and this works in depositions too, or mediations or arbitrations. If an expert, we use the example of a red light or green light, if the expert's testimony is the light was red, okay, that's what he, she, or they just answered. What you can do is then you're setting this up ahead of time. You want the trier of fact to hear this 3 times and without getting the asked and answered objection. So once the expert answers that, the hypothetical we gave is I put up in front of the jury that intersection with 3 lights and maybe a stop sign. And I asked the expert, could you step down and show the jury when you said the light was red, can you use this marker and do a big circle around which one of these 3 lights was red at the time the defendant allegedly ran through the red light. And so once again, now you've got this human being interacting in front of the jury, smiling, looking over, maybe stumbling, being human, right? But circling that red light. And so the light you just circled is the same red light you testified to 15 minutes ago under oath in front of this jury. Yes, that's correct. So that's the second step is following up using demonstrative evidence to the first question. And then when the expert takes the stand again, try to find another way to bring up that earlier red light answer, whether it's later on during the back and forth direct or cross-examination. You can always find a way to come back to that earlier important answer. When Betty Smith testified yesterday about the light being green, Mr. Rishwain, and we've talked about the circumstances behind where she was standing and the sun was in her eyes and the tree was blocking her view. Does that in any way affect the testimony you gave under oath 35 minutes ago in front of this jury that what color was that light, Mr. Rishwain? It was red, Mr. Jackson. Thank you. No further questions.
So this would be really, you've gotten to know the attorney a little bit. So this is something the attorney and the expert should know about doing kind of that dance, right? To do this
Yeah.
three-prong approach, but this could be a suggestion that the expert could make to the attorney about bringing in that.
Yes, I'm glad you brought that up. So I'll tell my expert, because this is something that I do in my trials. Look, Nick, when I have you on the stand, I'm going to ask you the question, whatever it is. I'm going to ask you to step down. And if there's some objections, just pay attention to what the judge rules, because the objection's asked and answered, but it's not a good objection because it's not the same question. And just go along with the questioning. I'm going to have you come down. I'm going to have you circle the red light. I'm going to have you take the stand again. That's all I'm telling you. I'm not telling you what to say. Right? You're going to get familiar with what we're doing. Imagine being an expert witness who is working with a law firm, whether it's getting ready for deposition or trial, and you're working closely with the lawyer, which is hopefully what you're doing. Maybe it's the paralegal. And you bring up, listen, instead of me answering this question, yes or no, and it's a yes answer, have you thought about backing it up using this 3-step process?
Mm-hmm.
And it's so effective that we do this in our jury selection. I do this in my opening statement. I'll refer to something 2 or 3 times in 2 to 3 different ways. I'll do this absolutely in my closing argument. You not only heard Mr. Rishwain from the stand tell you the light was red, because now it's already happened.
Right.
You also watched him walk over and stand in front of each of you and circle that red light. And then 35 minutes later, when we talked about the testimony from Karen's observations yesterday, which, by the way, everybody, give me a break. I mean, I'm serious. This is the way you do it.
Right.
Mr. Rishwain was definite and certain that light was indeed red because of A, B, C, D, E, F, and G. So it's just a matter of being repetitive will allow you to become more persuasive. And as an expert witness, if you share this approach with the lawyer that's trying the cases, especially if it's someone that hasn't tried too many cases, you're going to be their new best friend.
Excellent. We've got this one comes up all the time. It's come up in several webinars, but this person asks, how can you defend against an aggressive, rude, mean-spirited attorney in deposition? And they don't mean an attorney that's doing their job. This is more when they become inappropriate and unprofessional.
Well, it's actually the lawyer who hired you that put you in that seat. It's his, her, or their job to take care of business. And if that happens, that lawyer has the ability to stop the deposition, get a protective order with the court. But let's just say it's borderline. That's not going to happen. And so it's kind of up to you on how you handle this. My suggestion would be to do everything you can to avoid being Jack Nicholson in A Few Good Men. Don't let them get under your skin, because you can handle the truth. Okay. And what I want you to do is just keep your composure. Take the high road, be professional. Don't speak over the lawyer. Let he, she, or they say it, whatever it is they want to do, and then simply answer the question. I would say just take the high road every time, because right now, especially coming out of COVID, if we are coming out of COVID, right now, what I'm telling the young trial lawyers, and I think this applies to expert witnesses too, is we want to lead with empathy in the courtroom. We want to be kind to people and tough to issues. And that same lawyer who is trying to push your buttons in the deposition because they're trying to figure out what they can say to piss you off in front of a jury, that's what's going on there. It's a game. Treat it as a game. And if that lawyer tries to do that to you on the witness stand at trial, in today's world, 2021 and beyond, it's not going to fly. We've all been through a lot. People don't like to watch other people get beat up on the stand. If that same lawyer is firm on the issues, but kind in how he, she, or they ask the questions, then, they're going to be effective. So that's the way I would handle that.
Great. We have somebody ask, Nick, Mitch offered to answer any questions after this excellent webinar and to ping him. Only I can't find his email address or his firm's website. So Mitch, how do people get in touch with you?
So the easiest way would be if you guys want, if everyone would like to just shoot me an email at Mitch, M-I-T-C-H, at jacksonwilson.com. I'm always here for you. If you jump over to streaming.lawyer, there are all types of different ways. That's my legal tech social media blog where you can use the contact form, or you can connect with me on social media at Mitch Jackson on most of the platforms, or you can go over to our traditional law firm website, which is jacksonandwilson.com. All of those will result in your message getting back to me in my inbox. And I really, after 35 years, I just enjoy this part of my life and in answering these kind of questions. And if there's anything I can do, Nick, to help, you at experts.com or anyone in the audience, all it takes is a quick ping, and I'll be there as soon as I can.
Yeah, he's very great about these things, and I want to add to that. He mentioned streaming.lawyer as his website. His traditional firm website is jacksonandwilson.com. But you also may look up, Mitch does he's got a whole operation trying to teach lawyers some of the information he shared with you here today. He's got a mastermind group called legalminds.lawyer. You may want to take a look at that. In addition, if you can't find him anywhere, which you should be able to, go find him on experts.com, because he's a member of experts.com as well. But we are members of legalminds.lawyer. He's a member of experts.com, and we work on many of these issues together on a regular basis. I'm trying to see any questions. I know we don't have time here, folks. We're almost out of time. So,
you know what I think? Can I just add one more thing, Nick?
Yeah.
Because we talked about, look, after it's all said and done, how can you build your brand as an expert witness? How can you get your name out there? How can you differentiate yourself from everyone else? And I would suggest that if I was an expert witness, I'd be doing a weekly podcast or a weekly live video show. I'd be using StreamYard, for example. It's like Zoom, everybody, but when I click a button on StreamYard, it gets broadcasted to Facebook, LinkedIn, YouTube, Twitter, Amazon Live, all the different platforms with one click. Okay. So it's like Zoom, but it's just a little different platform. And I'd be interviewing partners and top trial lawyers of law firms who handle the types of cases that I'm an expert witness in. And I would absolutely make 100% of the show about them, about that recent court victory, about their years in high school or college playing football, or in the band, or in the arts. I would use these shows to kind of show the other side of a well-known partner, a lawyer, not only locally, but nationally and globally. Right. And just create one of these shows where you're legitimately profiling someone else. Guess what's going to happen? All of that lawyer's friends and people in the firm, they're going to be watching, partner Smith being interviewed and having this fun, easygoing interview, and he or she or they are sharing their lives. And it's kind of fun. We all like to talk about ourselves, right?
Yep.
If you do this often enough, what's going to happen is you're going to indirectly be known as that expert on premises liability cases that's available, because you're going to mention it every now and then,
right?
Especially in the description. But you're also someone that's adding value to the community, maybe a new trial tip each week from each one of these lawyers, their favorite approach to picking a jury. I mean, whatever it might be. And you're integrating yourself into their worlds. And by doing that, you're expanding your top of mind awareness, so that when they need an expert witness, or when another lawyer down the street at another firm needs an expert witness. Now, I was just on a show with Nick Rishwain. Super nice guy, really knows his stuff. We got to talk about my college football days, or my running, whatever it might be, which has nothing to do with my law firm, but I really enjoyed the conversation. That's how you get the referrals in today's world. So I just wanted to point out and emphasize, start a podcast or a live video show, everyone. Shine a light on everyone else. Don't do what everybody else does and talk about themselves and their business and how great they are. Just make it like a talk show.
Make it more relaxed.
I think they'll be surprised with what happens.
I'll add one to that I drive home for our members very regularly on experts.com. Adding content, which is what Mitch and I talk about all the time, is content is king. If you're uncomfortable with the video or the podcast thing that Mitch just said, on your Experts.com profile, if you got the right membership level, you can add articles, and they perform so well on search engines that I promise you it is worth it. Writing content related, that traffic engineer who is talking about autonomous vehicles, not all traffic engineers are talking about autonomous vehicles, and it's a hot topic right now. So describing maybe what things lawyers should be looking at, draft that content, publish it. You can really make a difference for your marketing, as well as, boy, I just read this great article from Mitch Jackson, who's a traffic engineer, really knows what he's talking about. I'm going to hold on to this, and when that case finally gets filed, I'm going to contact him. That's the beauty of content, and that's what Mitch is talking about with the podcasting, the videos. That's what we talk about on Experts.com. There's just constantly seeding the web, the internet, with information that highlights your knowledge without, you don't have to take heavy positions. That's what a lot of experts always worry about. You can inform,
from the 30,000 foot level.
Yep.
30,000 foot level, and do what Nick just suggested, and maybe focus on breaking news stories or trending topics that everybody's talking about today. So if you're a tech expert, and with Facebook, Instagram, and WhatsApp being out for most of the day yesterday, you could do a blog post or a podcast or a video. You're not criticizing anybody. You're just talking about, wow, isn't that interesting how we all rely on technology? And let's talk a little bit about internet security and some things that you may need to know. Or I saw Twitter put out a tweet mid-morning yesterday. It was Twitter. Hey, everyone, it's good to see you. So they newsjacked all these other platforms going down with people coming over to the Twitter. So think about riding the trends of trending talking points. And I think what Nick just described, you'll actually be able to put a little fuel behind to get more impact. And then Nick, once that content's out there, spend the time to engage and comment and respond to comments, right? I think that's where a lot of experts drop the ball, is they push their content out there and then wonder why it's just digital crickets. And I think the key is to tag, if you're writing something about Nick or me, you tag us in your post. We'll then share it out to our audience, and
it's building a rapport.
Building rapport, and you just engage with your social media content. If somebody takes the time to comment, then take the time, or have someone on your team take the time to like that content, or maybe thanks, Nick, for sharing your 2 cents worth. Really appreciate you.
Mitch, thank you so much. We're about 3 minutes past the hour. Folks, thanks for or past the half hour mark. Thank you so much for staying with us through the difficulties at the beginning. This will be recorded for those who are registered. We'll be sending it out shortly, or next couple of days. And thanks so much. This again is brought to you by Experts.com, and thank you to our host, Mitch Jackson. Mitch, have a wonderful day.
You too, Nick. Thank you. Thank you, Nabil. Everyone, make today your masterpiece. Bye-bye.
Bye-bye.